Thanks for coming.
Yeah, when I was contacted, first off, my name's Zaengle. I'm from Worcester, New York. I'm an oil and gas attorney and geologist. I grew up in Worcester. I got a degree in Afton in geology and hydrology. Got a master's degree in geophysics from Southern Illinois University. Worked as an environmental geologist overseeing the cleanup of hazardous waste sites across the United States for 9 years. And went to law school and then was a trial attorney in downtown Chicago for approximately 9 years prior to coming back home. I do also, I agree with Mrs. Long and Mr. Slotchke in that 20 minutes would be a difficult amount of time for me to cover the issue of whether towns have the authority to regulate oil and gas law under the environmental conservation law of New York State or the home rule powers of the town. But I was not asked to come here to address that issue. If you'd like me to give you a presentation on that, it usually takes 45 minutes. I got a PowerPoint presentation, and I can do that if requested. I was asked specifically to come tonight to talk about what type of legal implications a town might expose itself to if it passed a resolution similar to the Joint Landowners Coalition. And to that issue, I would respond that there are a lot of people say you can't pass these resolutions, or if you do pass it, you might subject yourself to legal action. I would say, first off, to date, over the course of the last 2 months, approximately 30 of those types of resolutions have been passed from towns up in Otsego County, Zaengle County, and other areas, and there hasn't been one lawsuit brought on. Now, I've heard from the opponents of these resolutions that, well, you have the town board members could be sued for conflicts of interest, and potentially that there are notice or public hearing requirements if you went ahead and passed these. To which the first issue, whether the town would have to have a public hearing prior to passing one of these resolutions. New York law said the town board is required to hold a hearing prior to passing a town resolution only if explicitly required by statute. I am not aware of any statute that requires town boards, when passing resolutions, to have public hearings. So that's the only statement I would have.
Can I interrupt one? Sure. Can you, if we turn this on low, is that air conditioning?
I've got a big voice, so I can probably talk over it. I'll be quick.
On low. Got the air on, yeah.
The Joint Landowners Resolution that's before you simply acknowledges that the Duke resources and expertise for carefully monitoring oil and gas activity in a uniform way across the state of New York is better placed in the DEC. And it's not to say that if you passed a resolution like that you would be including the town from doing what it lawfully can do under current New York state law. I mean, towns are given broad home rule powers, and under the interpretation that I would explain in response if invited back to this preemption issue, is that prior to any DEC permit being granted to a would-be oil and gas company that wants to drill a well in your town, the town board is notified of that permit has been filed and is given time to weigh in on, the road use issues, wetlands issues. They're given an opportunity to weigh in on unique features of their town that they want the DEC to consider prior to granting it. So it's not as if you'd be waiving that right. The main point is, I guess the decision you have to make is, are we going to rely on the DEC, who has funds, they have hundreds of employees that are experts in the field of geology and other technical areas. Is it better that they make a decision on regulating oil and gas, or do you feel like your town board has the resources and money and expertise to regulate oil and gas? Resolutions supporting strong state leadership and opposing local legislative bans are fiscally prudent for the community as well. Mrs. Long talked about the potential of being sued, that if you passed a moratorium, that, and if you did so before the DEC put out its supplemental generic environmental impact statement, that you would be better protected against takings cases. I would argue that you wouldn't be any better protected, because the takings cases are dependent on taking a right that currently exists. And if there are any landowners that are currently under an oil and gas lease in your jurisdiction, which I would say probably the likelihood of that is yes, there are, then the gas company that signed that lease has a valid property interest already vested and spent millions of dollars or hundreds of thousands of dollars to get those lease rights for the mineral rights. So therefore, if you come in, whether the DEC, before the DEC passes the supplemental generic environmental impact statement or after, there could be a claim for regulatory takings. She says that it's interesting in the Dryden and Middlefield cases that they were declaratory judgment actions and that there's no damages for claim. Well, if you understand what a declaratory judgment action is, you don't need to bring damages actions. What you're simply asking the court is to look at the state of the law and declare whether their rights have been violated or not. If it is found that their rights, that the towns do not have the right to place moratoriums and bans, then their decision will be overturned and the plaintiffs will have no damages. Now, if on the other hand it's found that they do have the right, then the claim for takings becomes right. And right after that decision is issued, an attorney could sue on behalf of the gas company or a landowner for a takings. So there's no point, you ask the court whether the town boards are right. If they're not right, then you remove the moratorium with nobody's harm. If the moratorium if the town is ruled to be right, the moratorium stands, that's when you would take and bring the action for regulatory taking. So there's no sense in doing the two at the same time. You want to see what the court's going to decide, and then that'll determine whether you're going to sue for takings or not. You know, they say that there's no. The other issue that is often brought up with this resolution, under passing this resolution, that is subject to the members of the board, potential conflicts of interest. Conflicts of interest law was created when for a town board when a member is asked to vote on a non-binding resolution or a matter where he is personally or his family has a personal and direct economic interest. It is not, there is no conflict of interest if a member of the board has an interest just like anybody else living in the community. For example, let's say a town board member owns a gravel pit, and there's a proposal on the agenda for the board to decide who to grant a contract for gravel products for the town. And one of the town board members actually has a bid in. That would be a conflict of interest if he voted. Typically, they would recuse themselves from voting because they have a direct economic interest. Now, to say that any landowner that could potentially lease for oil and gas has a conflict of interest on passing bans or moratoriums or resolutions like the one on the table before you is ludicrous. Because if that was the case, then 80% of the people to 100% of the people in your town could never act on the board. So as far as a conflict of interest, it's determined if they have a direct personal financial interest. They or their family. those are really the main issues. And I feel that looking at the case law right now, that it is very unlikely that if a resolution like that you're considering today was passed, that there would be any legal challenge. Like I said, 30 of them have been passed. Not one legal challenge. Now, as far as your attorney, his recommendation was to do nothing. Well, yeah, obviously, if he did nothing, didn't pass any bans, didn't pass any moratorium, didn't pass this resolution, well, you didn't act. So how could you be sued?
Right.
You know, but that would say both on the moratorium and ban and any resolution. But by passing this resolution, many of the towns that are passing it because they want to send a message that they're open for economic development in their town.
Right.
That's the key. So I guess the big question is, and it's a tough decision, I don't envy any of you on the board, is whether you want to put up where Town Afton is not open for business, or you're going to put up a sign that said, well, we're open for business, provided that we like what the supplemental and the DEC puts in place to protect us from the environmental issues. And my response to that is, if I was on the common board, I would feel comfortable with the DEC regulating oil and gas across the state of New York, more so than if my town in Maryland would weigh in on the issue and decide that they would be in business regulating oil and gas, personally. And, you know, to say that there's no takings, potential takings issues out there, I'll remind you that the Delaware County Board of Supervisors has threatened the city of New York and the state of New York that it's willing to take takings action on behalf of its landowners that are losing their mineral rights to the tune of $83.1 billion, $350,000 an acre. So to say that takings is just some kind of bluff, I would say that I don't think the Board of Supervisors in the town or the county of Delaware would likely bluff. That's all I have on that particular issue. If you have any questions, I can help try to answer.
Thank you.
You said the town can't bear the expense of monitoring the oil and gas activities. You read the decisions in the Dryden and Millfield, and I'm sure you know that in fact the towns aren't trying to regulate monitoring oil and gas activities. They actually pass bans, correct?
Well, you know, here again, the Dryden and Middlefield cases are the Supreme Court of New York cases, the lowest court in the New York State. These judges are very politically driven. They're elected officials. And it's not uncommon for their cases to be overturned on appeal. Now, as far as the appeal, yes, they haven't been filed, but I've been talking to Tom West and all the attorneys, both involved in the Dryden and the Middlefield case, and I assure you that they're going to be accountable. As far as...
But I'm talking about the distinction between having land use authority, for example, with zoning, is different than regulating gas. That's what those
that's what those cases...
Do you understand those distinctions?
Yeah, I understand those distinctions, and the distinctions are that the lower court has said that banning natural gas activities, drilling in your entire town, is somehow not regulated. To me, that makes zero sense. That'd be equivalent of a court finding that if your town board decides to regulate farmers and say no farmers or no dairy or milk production in our town is not regulation, I find that a stretch. And that's why I'm confident, and a lot of the lawyers in the state of New York that are involved in oil and gas and have been for the last 20 years, think this decision, these two decisions, the Dryden and Middlefield case, are going to crash. It could not be upheld.
And so, in fact, wouldn't it be safer to not act in terms of declaring what we are not going to do before we know what the DEC is actually going to do, doesn't it?
I don't really think that this resolution that's in front of you is deciding anything. It's simply saying that.
Why are these people who never come to town board meetings suddenly very interested?
Because
Well, I mean,
that's
but what I'm saying is that this resolution simply says, we're not going to do anything. We have confidence in the DEC. We're going to wait till the supplemental generic environmental impact statement comes out.
It doesn't
and we're
say
gonna
it's the
see.
last thing. It doesn't
That's
say
it.
we're going to wait. Wait. Are you saying it says, because we're not waiting, or at least if the board passes this resolution, it's not waiting. And I didn't see where the resolution says we're going to wait to see what the DEC says.
No, the resolution is simply saying that
Yeah.
it goes through, it says that a certain amount of hours, man hours, of creating 900-page comprehensive plan has been done by the DEC.
For example,
that they have the
let's stop there.
expertise,
Stop.
they have all this, and they've done. And the municipal governments of New York State, natural gas development shall still remain under the review of the DEC and the ongoing supplemental generic environmental process. Local municipalities will have a designated role under the state guidelines. Development of natural gas resources is currently prohibited pending the DEC plan and final approval anyway. Premature local action in our municipalities could negatively impact the competitive environment of all of New York State for natural gas development and jeopardize the potential of $11.4 billion in state economic impact and development, so on and so forth. I mean, that's what it says.
Question then. I think what I was trying to say is that the resolution doesn't say we're going to wait. And you know, you've read enough of it, people can make up their own minds. But for example, does this town board know how many hours, 10,250 man hours, of course, you know, I'm sure some of them are women, by the way. But I have no idea how many hours. We're going to have a resolution where we make resolutions, whereas clauses in resolutions are findings of fact, right? Right. So we're making findings of fact. Whereas the state is dedicated, and more than 10,000 people.
Is this your additional time that you get on your 20 minutes
No, I'm
that you were
asking
asking
you a
for? Because
Why are you being rude?
he didn't get to badger you.
She's on the town board, he's not.
She is still asking a question.
So,
It's okay.
I mean,
like that.
isn't it appropriate that whereas clauses be things that we, the town board, know? Whereas we know our town is divided on this issue of gas drilling, probably 50-50.
It's not this.
Why don't we do some
Can
whereas?
I answer your question?
Let him answer the question.
These things are being already, whereas
Yeah.
you know, can be, they're backed up by public available information. I mean, the courts would recognize these things.
Only after being introduced by an expert witness, right?
Right? Well, you know, I think
Are
that.
you swearing that the DEC is putting 10,000
He doesn't have to swear. His point was to inform us about any legal liability, which he has no doubt. And
Okay, thank you.
all right.
Thank you.
Thank
Is
you.
there any more questions?
Huh?
Any questions?
Yes, there can be.
I just have one question.
Yeah.
When you were talking about the DEC, we know that they're very understaffed.
Right.
All right. And they do a great job, number one. Okay, so the issue, I guess the question I have is, they're going to come up with this decision that they're going to present to who?
Well,
Who are they going to give their findings to?
you mean as far as with the
Yeah, when
supplemental
they're
generic
all
environmental
done,
impact
they've
statement?
decided that yea or nay, they should do this, they're going to present these findings to who?
The governor.
Okay. And the governor and his people can look at that and say, well, we don't really think that's right what they're saying, we can change that ourselves. So any good laws that maybe the DEC is saying, they can just take right out of the bill. Am I correct?
I would agree.
So it makes it pretty difficult to sit there and look at something like that. And I believe that there's a right way to do it. And I know that eventually it's going to happen. You know, that this is probably going to take place. But you're dependent on the DEC, and I know that they can put it in front of the people above them, and they can take it out. They gave a recognition to all matter. So here we are.
Right, and I think that the governor, with his response, he's been more than, he's letting them do their job, and they're the experts. He's going to review it with his team of people and decide whether it's something he can support or not. And from the indications that we're hearing now, it's likely that this, even if the supplemental generic environmental impact statement comes out, remember, it's taken 4 or 5 years. All sorts of thousands of pages of comments. You know, this is not been a quick action. And you know, so it's been totally vetted. If it comes out, there's indications now that it'll only allow drilling in the 5 southern tier counties where geologically they have superior oil and gas acreage, leasehold positions. And if and when the drilling occurs, then there's going to be significant revenues. All we have to do is look at our friends to the south, that they'll have the money to hire more people. I mean, it's a chicken or egg problem. Oh, the DEC right now doesn't have, people claim that they don't have enough people. Well, believe me, when the states start making $5.4 billion a year on there, they'll be able to hire a few people. Maybe I can start making money and paying money for my kids' braces and stuff.
You just called up here.
That's fine. I'll get you that.
You had brought up the conflict of interest issue before.
Right.
I just want to make sure I understand this. Within the last couple of years, I mean, I've gone to support meetings in Broome County, and the Broome County attorney at that time, Sluzard, had, he had told his board members that
Good job. Wait a minute. Fire that good.
And I was just wondering if the view of that has changed more recently, and the other aspect of it, which really has to come West. And he's been representing the gas industry in pollution cases, other cases that have for many, many years, according to his own website. And he actually was he actually was one of the primary authors of the original bolstering grazing laws, amendments to regulations and law to make it possible for hydrocarbon state. Do you perceive, would you think he would be liable to be sued for unfair interest?
Well,
what power would you go to?
right. Well, first off, Tom West, if he could be sued for a conflict of interest, and I guess every attorney that takes an advocate position for a client could be, I mean, that would be ludicrous. Because we all take that. You're right, Tom West serves exclusively on behalf of oil and gas companies. But I would say no to that. Joe Sluzar, as far as his recommendations to town board members, I can't speak for Mr. Sluzar and his recommendations and why he came up with that, but I don't agree with that. He might have been doing that out of the abundance of caution. I don't know. I have no idea. Did you have a question, sir?
Yeah, your legal recommendation seems to be based on how much gas is under the ground and how many people want it and how much money is involved in it. I think that you were supposed to address what is the legal implications of this.
So was Mary Jo Long.
What are the legal implications of this?
Mike, I thought he did an excellent job.
But you might say, well, he did that.
All right, so what's the question?
I have a question, since you didn't address this question. What will happen to the town of Afton if this is not? What is the impact on the town of Afton if this resolution is not passed?
Well, if nothing is done, then there would be no impact, like I said.
And that was answered in his statement.
Appreciate that.
Okay. All right. That's it?
Thank you.
All right, thank you.